Today I'm here with Barry Scannell. Welcome, Barry, to our live talk today. So Barry is a partner at William Fry. Today our topic is AI governance, compliance, and regulations. Let's talk about some of the unspoken challenges behind the AI Act. We see so many people posting about it and writing articles, but not everything is spoken about it. So what do you think are some issues behind the AI Act that people are not talking about, or some maybe unpopular things that you usually don't share? So some unspoken challenges behind the AI Act.
I mean, the biggest one by a mile is the issue of compliance costs. So when the when European Commission did their impact assessment for the AI Act, so the proposal for the AI Act was published in 2021. The work in the impact assessment started in 2017, 2018. And in the impact assessments, they try and figure out, one of the things they try and figure out is, how many businesses in the EU will be affected by this, how many AI systems will be affected by this, and what will it cost businesses to be able to comply with this. So to put things into perspective, when the European Commission has started this exercise of doing these impact assessments, the transformer, the technology underlying the famous T and GPT that we keep hearing about, it was only written about for the first time in a research paper in 2017. It was only deployed for the first time in 2018. So when the European Commission has started doing this, the technology that has given rise to the big explosion in generative AI, the technology didn't exist. So it's not really the European Commission's fault. So I think their estimates on compliance costs was, in a very literal sense, off by an order of magnitude. I think it was missing a zero. Instead of costing maybe 50,000, could cost some organizations that are really deep in the weeds on this, 500,000. So most of the work actually all of the work we're doing. So it might sound a bit crazy, but my practice is an AI practice. My work is almost entirely AI law. So obviously, I chip in and help out the technology group. It's like with normal technology queries that come in relation to copyright, in relation to transactions involving technology and software license negotiations, things like that. But predominantly my practice is an AI practice. And the type of clients that we have in our AI practice are major tech multinationals, major social media platforms, the big techs, and from an Irish perspective, they're Irish PLCs. So they're some of the largest companies in Ireland. And that's who's looking at AI at the moment. They've got just two reasons. One, they can afford it. And two, the bigger the company, the more likely it is that they've got a very advanced network and implementation stage of AI. I don't know how SMEs, smaller organizations, are going to be able to comply, particularly startups, when it comes to AI. Now, there are rules around, lesser fines for smaller companies. There's rules around regulatory sandboxes. There are measures within the AI Act to help startups and smaller organizations. I'm not sure the extent to which those will actually help. So I think the biggest unspoken issue by a long, long way is that if you're a small to medium organization, the compliance costs are going to be astronomical. And, for some companies, we're already seeing some organizations say for data protection reasons as opposed to AI Act reasons. But let's say Meta's rollout of their multimodal elements is one example. Apple's rollout of their multimodal AI systems, they're pausing that on a European basis because of GDPR concerns. And I think for a lot of smaller organizations, that might be writ large, because those smaller organizations might figure it's actually economically more viable to avoid the European market than actually have to go through the product regulatory process to get the CE mark to be able to provide these products onto the European market. So I think, there's just going to be a gap between bigger companies and smaller companies, and potentially a gap between products that are rolled out within the EU and not. But what I would say in relation to the EU, let's say with Meta's decision not to roll out their AI in Europe for the time being, So some people might see, and it's a very typical thing you see with Americans and Europeans. The Americans go, "You guys regulate too much," and the Europeans, like me, saying, "Yes, but we've got rights." The flip side of the coin is that our data, our European citizens' data, is not being used to train Meta's AI systems. And as a European citizen, somebody concerned about privacy, I see that as a win. So there's pros and cons to each side of it. So yeah, I think that's the biggest unspoken kind of obstacle for now.
You were mentioning that probably small and medium enterprises will have more difficulty with in terms of cost also, right, and bureaucracy and documentation. Do you think it will be much worse if the company is developing a high risk AI system? So if the company's business
Oh,
model is classified as high risk, or from your practice, what you're seeing now, it will be as well, other obligations will also be expensive, so it doesn't matter. What do you think?
yeah. So I mean, if your system falls into high risk, then you get, as we'd say in Ireland, both barrels of the regulatory obligations. You basically would have all of the compliance elements. So not only would you have to kind of risk avoidance and risk mitigation elements, but also you'd have the active obligations, which would involve the regulatory elements of getting the CE mark, which is for people who wouldn't know, if you want to make a product available in Europe, it has to have, it's a safety label, really. I'm not sure what the US version is. I'm sure there is a US version, but basically that the product, let's say if it was a child's toy, it's going to have a CE mark, so you have a certain level of comfort that it's not going to explode in your child's face. So high-risk AI will need to have the CE mark. It will need to have product regulation and everything like that. But here's the problem: to be able to, it's easy if let's say with high-risk AI systems, there's two types of high-risk AI systems. There's Annex 1 at high risk and Annex 3 high risk. So Annex 3 high-risk AI systems are coming in on the 2nd of August 2026. Annex 3 high-risk AI systems are things like AI that are used in the HR context, so recruitment, performance monitoring, profiling, AI that's used in profiling, biometric identification, access to essential services like health insurance, life insurance. That's all going to be considered high risk. So if you're in an insurance company, or let's take the HR context, if you're using an off-the-shelf HR software, that might have AI elements in it. And as a user, you may have AI Act obligations. Certainly, if you're providing this software into the EU market, you need to cover off, well, is this high risk? Because you need to be telling your customers, well, this is high risk, and you have to be able to show, you have to give warranties, presumably, in your contracts. You have to be able to comply with the European law, because if you're providing it onto the European market, you have to get the CE mark, you have to comply. So to get to that point, though, to know whether or not it's high risk, that in and of itself is not a small process. So what we're currently advising our clients on in terms of what steps to take, step one is always carry out an AI inventory, an inventory of all the AI systems either being developed by your organization or being used by your organization. And then once you've got that inventory, what you have to do is you have to go through a categorization exercise. So pursuant to the AI Act, what type of an AI system is it? Is it a general purpose AI system? Is it a high risk AI system? If it's high risk, is it Annex 1 or Annex 3 high risk? So Annex 1 high risk, by the way, those rules are coming in the 2nd of August 2027. And those are AI systems which are safety components or which themselves are actual products, which are regulated by specific European regulations, such as the machinery regulation, the medical devices regulation, things like that. So specific products that are covered by existing European product regulations. So you already have to undergo that exercise. And that in and of itself is an expensive exercise that would cost tens of thousands of euro if you are any type of sizable organization, because you're going to have to get lawyers to work with your tech teams to do that categorization exercise. And then where you identify any AI systems, which let's say if there's not high risk, let's say if it's general purpose AI, and the rules in general purpose AI systems are coming in on the 2nd of August of next year. And those are, foundation models, basically like ChatGPT, Copilot, probably going to be caught by it. Certainly, if you're doing fine tuning, for the elements that have been fine tuned, you're actually potentially going to be the provider of an AI model. So if you're taking an open source model and you're applying fine tuning with your own data, to the extent that the model exists as fine tuned on your data, you're probably going to be considered the provider of a general purpose AI model. And then as that model forms part of a general purpose AI system, you'll be the provider of the system as well, presumably. So like there's all of these different elements. And then, so is this a general purpose AI system? Are you a provider? Are you a user? And then there's rules that say, like, if you have a general purpose AI system that's, totally safe and fine to use, and if you make a tweak to it, so let's say you have an AI system in a school, and the AI system is used to correct students' essays, and you're telling one of your colleagues in the staff room about it, and this colleague works in HR, and they go, hey, I'm going to use that. That sounds like a really good system, because if it can grade essays about how good they are, I wonder could it grade CVs? And then you are the HR person, and you use that software and say, rank all of these CVs, for my American friends, resumes, from best to worst. And it can do it, and it can do a very good job of it. But under the AI Act, that's high risk, and that use is high risk. So you have a general purpose AI system that wasn't high risk, that is now, because you've changed the intended purpose of it, has become high risk. And under the AI Act, that would make you, the school in this instance, the provider of that. So that's why companies that are providing it need to say, this is what the intended purposes are. This is the acceptable use policy. If you stray beyond it, it's all on you. And that's why you, as a user of this technology, have to be crystal clear yourself, and particularly with your staff, to ensure that you know exactly what you can and can't use it for, because then you could get the full belt of the AI Act inadvertently. And that's why, training is going to become so important. And I'm sure we'll get to that, Luiza, but it's strange for a piece of legislation to say it, but Article 4 of the AI Act is specific. It says it deals with AI literacy, and it makes it a legal obligation for companies to ensure that their staff and people using AI systems have a sufficient level, depending on their roles, of AI literacy. This basically is a legal obligation to train your staff. And I think it makes a massive amount of sense, because you're going to be creating AI policies and procedures. First of all, you need to train your staff on these new policies and procedures, but you're going to have to tell your staff, the legal people are going to have to write the rules of engagement. So a friend of mine was in the Irish Army, he's a lawyer, and what the lawyers end up doing, at least in the Irish Army, I don't know what it's like elsewhere in the world, the orders come in, and then it's up to the lawyers that are deployed to put the orders into the rules of engagement. So that's basically what the role of lawyers is now going to be when it comes to things like acceptable use policies from AI systems, is that you're going to see the acceptable use policy, and it's up to the lawyers to put that into language to all the staff within the company, realizes this is what you can and can't do. And training is going to be a key part of that.
So you've already anticipated some of our other questions. So, but I'm happy you said right in the beginning. So I think some people in the audience are probably nervous because they didn't think they could potentially be high risk or providers of general purpose AI models and so on. And I think also I have some unspoken challenges to talk about also, but on what you just said. Also the geographical scope, right? So many people, they say, I'm not in the EU, so I'm out. And then they will realize that actually their AI system generate effects in the EU, so they will also be involved and be covered by the AI Act. So it's interesting that even if you're not in the EU, you might also be covered. So
the AI Act, like at that point, Louise, the AI Act is more extraterritorial than a lot of international treaties. There's a lot of international treaties that are a lot less international than the AI Act is. And that's because
For,
the
for,
Europe.
all, for all the Americans that keep saying that's your problem, you guys, you just know how to regulate. So we'll say, wait a minute, maybe it's also your problem. Just before we continue, so some of the things. So I think we're going to discuss it in other questions as well. But I think I would say more generally, but there are many exceptions that make me worried. So I can say some examples. For example, the article that allows companies to apply for not being high risk. So if you're within Annex 3, you can still there are mechanisms for you to say I'm not, despite being in Annex 3, I want to say that I'm not high risk. So I think that exception is too broad, especially because the paragraphs of this article that enables companies to avoid these classifications, they are very broad, and I can see many lawyers focusing on that, and I think it's probably so the result of at least the legislative technique used in this article, I think as a result there will be less companies classified as high risk than originally planned. That's how I read the exceptions. I think this is one.
You see, the interesting thing about that, Luiza, is that so there's a number of derogations that can apply to high risk systems. So not only must you fall within Annex 3, the different categories, but also there's these derogations. Basically, not only must you fall in high risk Annex 3, but also you must decide, is this actually high risk? Now, the thing is, if you decide as a company, okay, we're not actually high risk, you actually still have a regulatory obligation. You have to register your decision that it is not high risk with the relevant body in the EU. So there's still paperwork to complete. There's still a paper trail you need, and there's still an audit trail that you'll need. And, you know, from everything from insurance and like getting legal, if you consider your warranties, indemnities, liability clauses, if you as an organization decide, oh, this isn't high risk, and then you deploy it and you've assured everybody, all your customers, this isn't high risk, like the scope for problems is huge. It's not just limited to a regulatory problem. It's endemic. It can metastasize basically, because then let's say if you're wrong, or if the regulators disagree with you, not only then are you in default of the regulations, but all your customers are as well, because they've been assured by you that it's not high risk. So this is a big issue as well. And they've started in the EU, so there's been recent elections within the EU. I think broadly speaking, and you probably agree, Luiza, not much has changed in terms of the European Parliament. There hasn't been a massive shift one way or the other. I think it's more or less the same as what
You're
we've
probably
had.
more involved than I with European politics, but I agree with. I will go with you on this, Barry.
But they've already started talking about the legislative proposals for this legislative session. And one of the things they're picking up again is a piece of legislation called the AI Liability Directive. Now, I mean, if you're considering whether or not you're high risk, that's one thing with the AI Act. But the AI Liability Directive makes it way easier to get sued in relation to AI. So it's introducing this thing called, it's a rebuttable presumption, but a presumption of causality. So, you know, we're all, many of us anyway, are lawyers here, but, you know, typical tort law, especially in common law countries, you have a duty of care. If you breach that duty of care, then you have to link that causally to the injury, and then you get your damages. Well, with the AI Liability Directive, all you have to show is that there was a duty of care and that was breached, and the court can then infer that it was the AI's fault, and you don't have to prove that causal element. So one of the breaches of duty of care that it's introducing is breaches with the AI Act. So if you breach any of your obligations under the AI Act, and that could be a breach of something like AI literacy, that would be actionable under the AI Liability Directive. Now, if you consider from an IP perspective, a lot of the IP claims in the United States, in particular against AI companies, are failing because they're saying, oh, you use my copyright, and the AI companies are going, well, our training data is a secret, so you can't tell that for sure. And like it's true, they can't tell it for sure, even though it might be quite obvious, but you need to be able to prove that. Well, the AI Liability Directive actually allows for discovery, or a type of discovery, disclosure of data and information at a way earlier stage. So you'll have your traditional legal discovery, but the AI Liability Directive allows for disclosure in relation to specific elements at a much, much earlier stage when proceedings are issued to allow you to be able to maintain your claim. So we're not just dealing with regulatory hazards here, but there's also a lot of unseen liability mines that are concealed as well.
Very interesting that you brought the AI ability just on the topic of high risk. So if you're high risk or you think you're not high risk, so make sure to hire Barry, then you don't run into problems later on. So let's continue. We have so many questions for today, and for example, when you mentioned a little bit about small and medium companies, so many startups and entrepreneurs, they want to do things right, and they are worried with the AI Act. So what do you think in terms, especially from your perspective as an AI lawyer, what they should do first? So let's see, we have some people here in the audience that are entrepreneurs, and there are two types of entrepreneurs, right? Those developing AI models or AI systems, those really focus on AI, and those that will use more, I would say, tangentially use AI. So how they should start from, if you were giving this general tip. So what's the first step?
Well, step one actually is assess your risk appetite. If you've got an enormous appetite for risk, you might decide, I don't have to spend too much on complying here. I think they'll just focus on the big tech companies, and they're not really going to pay much attention to a small startup like mine for the time being. And if you've got a big risk appetite, I mean, good luck. Hope that works out for you. So, I mean, that, all jokes aside, that's the way the world works. That's the way law works, is that if you've got it was the same with GDPR. You had a lot of companies, especially smaller companies, go, they are not going to pay any attention to us when this comes in. And that's why you had companies that were actually only affecting their GDPR compliance 12 months, 18 months after it actually came in, because, well, they turned out to be right, that, the focus wasn't going to be on them for a long time. So do I think that's an advisable way to go about things? Obviously not. I will never in a million years, as a lawyer, say that, go off and don't comply with the law. Obviously, that's an enormous risk. But if you feel that it's a risk that you want to take, that's on you. But I think, if you do decide, well, actually, this is something I need to address, which would, I think, be the proper course of action, the inventory is the starting block. Always, no matter how big or how small the organization, the inventory of AI systems is always the starting point. You carry out your inventory to identify what AI you're using. And sometimes you might even be surprised, this is an AI system. And you have to work with your tech teams, looking at the definitions within the AI Act, getting the assistance or advice from external lawyers if you need to, and do that AI inventory. And then you can start the classification process. Is this high risk? Is this a general purpose AI system? And look, you might find, okay, looks like we came out of this unscathed, guys. The AI Act doesn't apply to us, or at least not in a big way. And then you can, if you are potentially caught, you can start looking at your obligations, as in what's your role? Are you a provider, a deployer, and so on, and what are your various roles? The inventory is the starting point. So there is a lot you can do internally without involving, external lawyers and so on. But carrying out that inventory is step one, and basically what we call an AI impact assessment. So, Luiza, you mentioned that there's a lot of privacy professionals on this. So most people ought to be familiar with the concept of a data protection impact assessment. An AI impact assessment is basically along the same lines, where you look at the technology, what's its intended purpose, who it's going to affect, what are the risks, and what mitigation steps have been taken, So, and to be honest, I think these are things like I see it in the comments here, and I get it always at international conferences, about this real hesitancy and resistance towards the AI Act. Most of what's contained in the AI Act, in my opinion, is stuff you should be doing already. If you're developing AI in particular, you should have AI governance frameworks in place. You should have data governance in place. You should have risk mitigation in place. you should have human oversight in place. So the general public has a level of hesitancy towards AI. And I think the reason for that, and I'm not being facetious, it's down to science fiction. The only exposure the general public has had to AI are dystopian science fiction narratives, typically. And AI has only ever been portrayed as a nefarious type of technology. And I think stakeholders, be they shareholders, your board, your C-suite, your employees, your investors, they're going to expect a level of responsible AI within your organization, and they're going to be able to expect you to be able to show that. So, DEI is so important these days for companies. ESG is so important these days for companies. I think being able to show that you are deploying AI in a responsible fashion is going to eclipse those in importance for stakeholders personally.
And you mentioned a few times AI inventory. And my view is that probably organizations that are already doing data protection right, and they have a robust department with processes and with well organized, probably it will be much easier for them to start with the broader data governance, AI inventory. That's my view. So how, especially if they want to be focusing on the AI Act and doing all the documentation, if they are high risk, or probably if they are doing data protection right, is already a great step. So if they're not doing data protection right and they don't even know where the data is, so it's probably going to be even more risky. Do you agree with me? What's your view in this relationship between data protection, compliance, what they're already doing? So how can they think in terms of, okay, so I'm already doing data protection right, so is there something that I can build from this that I have already built? So maybe especially thinking about not big tech or companies with more than 1,000 employees. Let's think of that small startup with, I don't know, 20 employees that has maybe an outside lawyer doing the data protection work. So I think that's the most challenging. So there are not so many people involved. So the CEO has to think about that. So that's where I think, from my view as someone, I've in the past, not many people know, so I used to be a partner of a law firm focusing on working with startups. So I've in my life, I've spoken a lot with early stage entrepreneurs, and they are lost. They have no idea where to start, what do I start? I have a product, it works, but I want to do the legal part right. So I personally think, especially for smaller companies, I think building upon what's already built in terms of data protection is a good start to think about AI. You have some thoughts on that, Barry?
Yeah, I think what is AI? It's a data processing technology. What is data protection? It is, rules and regulations in relation to personal data processing. Invariably, the data being processed by AI systems will include personal data. Therefore, I wouldn't even describe it as an overlap. In many ways, they're the same thing. So you're correct, as you correctly point out. There's no reinventing the wheel here. You're basically expanding existing frameworks, or going down a tried and tested route and replicating that existing framework. I mentioned DPIAs and comparing them with the AI impact assessment. You have an idea of what's required there, and a huge element of an AI impact assessment is actually the data protection impact assessment. And when we drafted our AI impact assessment, a big component of it is a DPIA, because that's a fundamental feature, certainly under GDPR, under European data protection rules, where you're using new technologies to process large amounts of data, you're actually required to carry out a DPIA anyway. And there's references to it in the AI Act as well. So I think they're fundamentally linked. Now, here's the interesting thing. You might say, okay, so the DPO should be responsible for AI. I would say categorically not, because there's rules that say that the DPO cannot dictate the data processing. But if you're in charge of AI within your company, your job is to dictate how the data is processed. So I think there's an inherent conflict between those roles. We have seen with certain clients that AI has been moved into a kind of a data role. So the data protection role within these big organizations has been subsumed into a larger data role. So there's now a head of data, and under data, you'll have data protection, you'll have AI. So that's one way of the way it's coming about. but it seems to be falling under risk, compliance, data, like one of those headings.
Thank you for adding
So
that. Continue.
yeah, I think if you're a small company doing data protection the right way, I think, you know, what you've done for data protection, replicate it, you know, is the best advice I could give. But you see, the thing is that I've described it before and I'll say it again. The AI Act is the GDPR on steroids. The GDPR
Interesting.
doesn't require GDPR doesn't require product registration. It doesn't require product regulation. It doesn't require having to deal with market surveillance authorities and dealing with how, you know, annual checkups and annual reporting for products and all of this. So I think there is that extra element. But if you're looking for some place to start, I think, you know, that's a good place to start. But it's a starting point. That's how I preface it.
So for the audience, if AI is autocomplete on steroids, so the AI Act is GDPR on steroids. So now we have the whole plaza. I'm kidding. So it's an interesting comment, and thank you for pointing out that. I think it's an important comment on the DPO. So for those not in privacy, data protection officer, there is this requirement of being an independent figure, right? You cannot dictate how data process internally to the company works. So it's interesting that you pointed out that some companies are doing this. I think it's very important information here for the audience. So this idea, what is really Barry's insight from his experience, that companies are organizing it in terms of data. So we have this data department, and then there's data protection on one side and data governance on the other side, dealing more with AI. So I think it's a very important comment. So let's move to some specific topics in the AI Act, which I think are very interesting, and I think also many people are curious. You mentioned that many people, they think of AI as this science fiction monster that will come and conquer us. But AI, actually, if we think of AI, we are already living with AI in an ubiquitous fashion. I would say at least for 20 years. So if you use any social network, you have your newsfeed. Your newsfeed is AI powered. If you have advertising, so you're being shown as this behavior advertising is AI powered. Or recommendation, if you buy something in e-commerce, the engine that recommends you to buy something else, it's already AI. So in terms of not generative AI, but some sort of AI algorithm, which is personalized, which is learning about you and learning from the statistics and suggesting things based on other people's behavior. So we are living with AI for at least, I would say, overwhelmingly we are living with AI everywhere. I think probably at least since social media started everywhere. We are seeing AI, and of course generative AI. I would say that the beginning of this generative AI wave would be November 2022 with the launch of ChatGPT. We have this boom of generative AI. Millions of people suddenly started playing or using ChatGPT and other AI chatbots for productivity and so on. Just to a brief comment on this idea of that AI is something either is not new. Even if we think of the field of AI, it started in the 50s, right? It's much older. I would say, of course, in the 50s, people didn't have computers at home. So of course, things evolved, and the most advanced types of AI, they are here for 10 to 15 years. So let's talk about some interesting AI applications that have legal implications. So emotion recognition, I saw very recent posted an interesting review of how the AI Act deals with emotion recognition. So I have a few comments, but I want to let you're being so educational today, but I'm so happy that that many in the audience, they are not familiar. So because we are in this AI bubble, and at least I write every week and I teach in my boot camps about the AI Act. So for me, it's everything obvious. Of course, everybody knows it. Of course, everybody knows Article 6, but no, people don't know it. So I'm glad we are supporting AI literacy here, as Barry mentioned. So Article 4 says that AI literacy is a legal obligation for everybody. If you're working in an AI company, if you're developing AI, if you're a deployer, a provider, you must know about AI. So we are also supporting AI literacy. So Barry, you want to speak a little bit about emotion recognition and the AI Act. So maybe also start with some concrete examples, right? What is emotion? Sometimes people read, okay, emotion recognition. So I'm probably not doing that, but maybe you are doing that. So you want to say something about it?
So, when OpenAI had their live, and of course I'm such a nerd, an AI nerd, I was watching it live,
Oh,
and they
it,
had
yeah.
their live announcement of GPT-4o, their latest model. So it's multimodal, and what that means is that it's able to work by text, by audio, by video, and through using these different media, it's able to identify human emotions. So it live on stage was able to assess the emotions of one of the people on the stage, and it's fully capable of doing emotion recognition. And AI systems have actually been able to do this for quite some time. It's based on, it might be based on different factors. You know, you might be familiar already with what's called sentiment analysis. So if you're writing an email and if you're pretty ticked off with the person you're writing to, the AI might say, hey, do you want to bring that down a bit and make it more friendly? That's been around for a while, but the emotion recognition systems are getting more sophisticated. So when they were developing the AI Act, it is interesting how the lobbying went. So actually Airbus were involved in some of the lobbying because there's a derogation in one of the recitals of the AI Act, which says that, let's say with AI systems that monitor tiredness of pilots, that's not included. And because Airbus they have those systems in the pilots' cockpits, and they didn't want, like, you know, is sleepiness, is tiredness an emotional state or a physiological state? So they specifically derogate from physiological states. So in relation to the education setting or the workplace setting, any AI systems that are capable of emotion recognition are going to be prohibited, banned from the 2nd of February. So the rules on prohibited AI systems and AI literacy come in on the 2nd of February of next year. So what does that mean? Basically, it's not talking about AI that can say this is a happy face, or this person is frowning, this person is smiling. That's not what it's capturing, and it specifically says that in the definition. It's AI that can identify emotional states. So this person is angry, this person is sad. So if it's used in the workplace or the education setting, that's prohibited and it's banned. So that's where we're going to be in relation to emotional recognition, and where it's not in the workplace environment, where it's not in the education setting, it could be considered high risk AI under biometric identification. So I would be just very cautious when developing, using emotion recognition AI systems.
But I think an important comment here to add is that still in educational and work settings, it is allowed if you show that it's for safety or health reasons, right? And then
yeah, for medical or safety purposes. So yeah, absolutely, there is that derogation, because obviously if somebody's having a breakdown or something and it's used there or something like that, then it's used. But in terms of normal practice, it's where it's banned. But you have to be able to show it's for those safety or medical purposes.
Yeah, here when I read this article, I always think of a malicious company. Or in some countries they have those facial recognition systems to monitor employee productivity, right? So they want employees that are extremely energized, and if you show that you're tired, if you show that you're constantly angry, or as you mentioned, some sort of emotions that the employer doesn't think that are suitable for the workplace, then the employer might fire you, and so on. But unfortunately, I think the exception here is another weakness. So I can see employers saying that they might find some sort of safety reason, but what they're really trying to do is just an example, right? Monitor employee productivity, which I think was that's why it's banned in the workplace as originally that was the intention. But I think that the language used and the way that the exception is framed, I unfortunately think that there will be many, if the company really wants to monitor that way, they will find loopholes. So this is just my quick comment on emotional.
See, but that would then fall under the performance monitoring element of the high risk of the use of AI in the workplace. So I think any type of employee monitoring, any type really involving AI, is going to be considered high risk. So, like, let's say in a law firm environment, we've got AI systems as part of our time management that captures time. Now, is that a form of performance monitoring? Like, do we need to turn off that element of the AI because it is AI, it is performance monitoring, so is that high risk AI? So there are going to be these fringe cases where, like, you see, now the thing is, though, is that that's one of those examples where you carry out the derogation exam and you'd look at the different derogations and you decide, as I would be quite confident in deciding, that is not a high risk system. But still, as a user of that system, you would still have to say, or the deployer, the provider of that system, you'd still have to say, no, this isn't high risk. You'd still have to register that with the EU. So, there's a lot of things to consider here.
I'm happy that you're confident in the EU bureaucracy that they will catch. And here, a bit of what we are discussing is what we learn in law school, right? The spirit of the law. So what the lawmaker, or what's the real goal, and what will happen on the ground. And sometimes, at least, it's not compatible. I think we'll see in practice. Let's see how it works. So I see that you trust the European bureaucracy, and you believe they're going to catch whoever is doing something high risk is going to, it's going to be to fall in some of the nets. It's going to be caught. You're not going to be able to. No,
it's not going to capture everyone, but I'd rather have these regulations in place than not. I think, and it's becoming this unique European thing, like about protecting fundamental rights over innovation or profit. Like, for me as a European citizen, I find myself in a strange position saying, hey, I think protecting my fundamental rights is better than a big company having profits. So, that's what's behind the DSA, that's what's behind GDPR, that's behind the AI Act. So, like, new rules coming in, like the Audio Media Services Directive, the Digital Services Directive, they're making the internet safer for my kids. So, by the time my children, when they're in their mid 30s and they get their first mobile phone from me,
30s. Wow.
Like, that's if they get their way. Ideally, they'll never get one. But I do feel that European regulations is making it a safer place for children to be able to be online and things like that. Regulating social media, I think that's important. I do think that's important. Like you were talking earlier about recommendation systems. There's prohibited elements of the AI Act that deal with use of subliminal techniques, AI systems which exploit vulnerabilities based on things like age. That's a good thing. So we already have rules in the DSA in relation to recommender systems. These are now going to be supplemented by rules in the AI Act. So where you have, there's one of the issues in Ireland at the moment, that's been talked about a lot in relation to recommender systems, is eating disorder content being pushed to young girls. That's obviously not a good thing to happen. But now, because of what the EU does and the teeth that the EU gives to regulators, we can put a stop to that and really help people and make it a safer environment for children. So I think overall that's a good thing. And what I say in response to these things that, the EU is stifling innovation, I disagree. If you're a company in Boston, you're no better or worse off than a company in Berlin, because if you both decide not to make your product available on the European market, you're starting from the same spot. You could actually argue that the company in Berlin is better placed because they've got an existing framework and all of these guidelines to help them get their AI systems off the ground that aren't necessarily there in states without regulation. So if you decide to not deploy into EU, you're in the exact same spot as any other company that decides not to place a product on the EU. But if that Boston company decides, I want to sell my AI product on the EU market, then they're there in the exact same position as a company in Berlin that wants to sell their product in the European market. So I don't see this as stifling innovation. That's my personal opinion.
Thank you, Barry. And let's continue with those more specific topics. I think one of my favorite ones, at least discussing also from a policy perspective, I think it's very interesting. So regulating deepfakes. So the AI Act talks about deepfakes. So what do you think will be the main challenge? So this is something that I'm passionate about. I write a lot about that, about the concrete cases and the harm and the people involved. So what do you think, the way that the AI Act regulates deepfakes? So how is it enough? Are you do you think it's going to work in practice? What do you think are some of the challenges, unsolved challenges in regulating deepfakes?
So here's the thing with deepfakes. I don't think so. Deepfakes are an issue. I think they're dealt with appropriately in the AI Act. I'll go into that, but I don't think deepfakes are as big a problem as they're presented to be, and this is why. If you look at social media platforms, like there was a viral photo that went around about 6 months ago of a ship that was on fire, the cargo ship that was on fire. And the post was that another American ship has been missiled by Houthi rebels. But that's not what the picture was of at all. It was a picture of just a random ship that happened to have a fire in it. It was taken 5 years ago. That wasn't a deep fake. You don't need a deep fake. For most of the information online, people are very good already at just being liars and just being bad people. For the majority of misinformation and disinformation online, you just need bad people who are lying and regular photos out of context. So, before Joe Biden announced that he was stepping back from not accepting the nomination, there was a video going around at the D-Day commemoration in France, and it showed him, it seemed that he was doddering off on his own from the group of leaders. But that was a cropped image. He was actually walking towards a parachutist. But that went viral online. Was that a deepfake? No. It was a cropped image or a highly edited image that was used and used out of context. So I think that'll continue to be the problem. Now, that's not to say that there isn't a problem with deepfakes. You had there was a story of, I think, again, it was a Joe Biden voice, a robo calling people saying, you don't have to vote. That's a problem. But going on to how the deepfakes are dealt with, under the AI Act, synthetic content, so content produced by AI systems, is going to need to be marked as synthetic content in the metadata. Now, where it's involving someone like a public figure or public information, something like that, it'll actually need to be watermarked. But here's the thing. Those bad people online that are so adept at just editing a photo, or so adept at just lying, they're just going to crop out the watermark. So that's the problem. And there isn't any real other way of dealing with it.
Yeah, very interesting. First, that you pointed out that the big problem, usually one of the main big problems in deepfakes, is spreading it. So if you have something, a fake image that you want to cause harm, and then you need some engine to spread, and usually the engine is social media, and it's already happening, right? We see it now. It's approaching American elections, so we see basically every day a new deepfake. So it's good that you pointed out that even if we solve the deepfake problem, if we manage to have content provenance signs properly in place and disclosure in place, lies will never go away. And if we have social media, we're going to be able to spread lies really fast. So even with the AI Act, I don't think it's unrelated, right? With the problem of fake information, regardless of AI and image or audio edition, we'll still have the problem of misinformation.
It's important to point out though, as well, is that these are extra things on top of what's already there. So if there's a deepfake of you doing something illegal, that's just defamation. You already have legal recourse anyway, so I think this is meant to help the general public, but we already have rules around, I see some of the comments there about deepfake, sexual acts, deepfakes, in certainly in Ireland, in the UK, in most of Europe, it's illegal already to publish deepfake images of somebody posting someone's face on a pornographic film. That's already illegal. There's already legal recourse there. There's already legal recourse there in terms of defamation, things like that. So we're talking specifically about how the content itself is dealt with. And again, if you have an AI system that's able to put someone's face on a pornographic video, that AI system probably isn't going to be complying with the AI Act anyway. If the AI system allows you to use the AI system for illegal stuff, I doubt it's going to be massively concerned about, oh no, we need to watermark this illegal content. So, and I think you hit upon a really important point, which is, I think when it comes to deep fakes and how it's dealt with, in terms of misinformation, disinformation, we're looking at the wrong type of AI. The AI we need to be concerned about is the recommendation system AI. It's not so much the deep fakes, it's the actual recommender systems that pushes this viral misinformation.
And just still on deepfakes, a quick comment. So Article 50 of the AI Act talks about two different types of ways to help deal with deepfakes. So one is for AI providers. So you, as Barry mentioned, so you have to add some sort of metadata to show authenticity. So someone was posting here C2PA, so content provenance. So you need to watermark to add something to this image, the metadata, to show that is synthetic. And here we have a technical issue so far, right? So even if you look at OpenAI's website, they say content authenticity is not the best strategy because it's so easy to remove. So for example, if you screenshot an image, if you're talking about a fake or an image, any image, if you add some metadata to show that is real or this is original or that is synthetic, if you screenshot or if you upload it on social media, you basically remove the metadata. Most social media platforms currently remove the metadata. So even by mistake, not maybe you wanted to just screenshot and post it to show other people what you just found, and then you remove the metadata. So this is really a weak. So the AI Act expects us to have a high standard metadata technique for content authenticity, and we still don't have. So this is, I would say, a still interesting technical challenge. And also,
and I think that the biggest issue for deepfakes isn't so much the conversation we've been having so far here, but I think it's actually in the likes of financial services and fraud, where more and more financial services institutions are relying on biometrics and, sending a selfie in or, this biometric authorization, and increasingly, like these attacks, I think every company will be familiar where the CFO gets an email from the CEO saying, "Oh, hey, emergency! We need you to transfer 50,000 over to this account. Thanks." And they've just hacked the CEO's account or whatever. But now, and there was this issue in Hong Kong where it was actually done by video.
Yeah. And there was a deep fake of the CFO, of the CEO authorizing the transaction. So really, you started with a phishing attempt, and then he was suspicious, and then they say, okay, so let's jump into a call, and there was a deep fake of the CEO or CFO, right?
It'll be interesting to see how the that investigation goes. I'll be keeping a close eye on it, but I think that is an issue increasingly. And how do you ensure that your staff, we all are sick of this training. I'm sure we all get the same types of training in relation to how to deal with phishing attempts and so on. But, the problem, I think the big problem with deepfakes is from a cybersecurity perspective, it's that it makes social engineering significantly easier. And it makes it a lot easier to trick people from a fraud perspective. So that would be my big concern in relation to deepfakes. And you can regulate until the cows come home in terms of deepfakes. If you are a criminal that is going to be doing this, you're not going to be bothered by what the EU or anyone else has to say in terms of regulating deepfakes. So that's part of the issue as well. So, that's why you have the likes of Interpol and Europol spending a lot of time and resources in dealing with the deepfake issue as well, because it's a huge criminal issue, not just in terms of AI Act regulation.
Thank you, Barry. So I know you're busy today, so we will have to skip 2 questions. We will soon have to finish, but I want people. It has been so interesting, this conversation. I want people to get to know your personal opinion a bit more. So regarding AI tech or regarding AI in general, I want everybody to share with the audience. So how do you feel about it? So are you, in what team are you? So are you optimistic? Are you excited? Do you use AI? Do you think that AI is overall benefic and we're going to have a lot of positive outcomes from it? Or are you more in the skeptical team? So I don't want to use it so much. Maybe you have ethical issues with it. or are you worried? Are you more focusing on what can go wrong? So it's interesting to see how the AI debate is very polarized. Kind of some people have taken extreme positions of AI is extremely bad and everything that comes out of it is probably bad, or AI is always good and it will solve all humanity's problem, and some people with ethical issues. So I would like to know your personal take on it. So do you use AI? How excited are you about it? What's your personal opinion?
There's two Shakespeare quotes I always use when talking about AI and what my thoughts are. One is, nothing is either good or bad unless thinking makes it so. So, AI isn't going to be a good thing or bad thing. It's how people use it, like any other technology. And the other one is, there are more things in heaven and earth, Horatio, than are dreamt of in your philosophy. So in terms of whether AI is good or bad, I personally think it's going to be great, provided that we regulate it properly. But we're doing a lot of work with healthcare organizations at the moment and medtech, and we're seeing what's coming down the tracks in terms of AI. And without any exaggeration, AI is going to add not just years, but potentially decades to people's lifespans. It's going to be able to discover cancers before you even get it, because it's going to be able to identify different biomarkers over time and how biomarkers change in massive populations. It's really going to have a very profound effect on society. And the thing is that people ask for predictions. And, when the printing press came in, when Gutenberg's printing press came along, nobody foresaw the implications that would have. I mean, when somebody developed the ability to mass produce books, would they have foreseen, well, this is going to cause a great schism in the Catholic Church, and it's going to cause Catholicism to branch off from Protestantism, and there's these unforeseen consequences. But I'm extremely optimistic about AI. But it's predicated on us being sensible with it. And there are, signs of hope that we will be sensible. So the AI Act doesn't cover military uses of AI. And we are already seeing militaries around the world using AI to kill people. And there's attempts being made by the US to have an international treaty signed that AI will never be allowed to make a decision to launch a nuclear missile or nuclear weapons. And there's hesitancy about that. I guess the current state of the world with Russia and China and the United States and Europe and NATO and everything else going on, that treaty is in place. And if you're to be scared about anything with AI, that's what you should be scared of, is that we don't have that treaty in place. And, I know I mentioned dystopian science fiction earlier, but there's a reason that virtually every dystopian science fiction involving AI involves the AI having access to nuclear weapons. Now, I'm not saying that the AI will get sentient and decide to wipe out humanity for that reason. I'm saying the AI is just a data processing technology that we're handing over nuclear weapons to. I think that's bad, for the record. But I think in terms of civilian uses for AI, I'm extremely optimistic. But I'm really hopeful that from non-civilian purposes and uses of AI, that we treat it very, very carefully, because I think it has capacity for enormous harm. So that's where I stand.
As you just spoke about nuclear weapons, let's move to a more optimistic topic. Let's talk about jobs and employment. And so many people in the audience I've been in touch with. So in my boot camps, I have one-to-one calls with the participants. And I know that so many people are interested in transition to AI. So there are many privacy professionals, they are trying to transition to AI governance. So many people, students in law school, they are asking, so how do I specialize in AI? So how do I get a job in AI? I'm not a developer. So many people are like us, Barry. They don't develop AI. They don't know how to code. They don't want to learn how to code, but they want to work with it in AI. So AI governance is a big thing, right? Became a thing. Now people are getting certified. So there's a big market blooming out of it. So I want to ask you, so as a partner of a prestigious law firm, so many people would like to work at William Frye and other law firms like yours. So if you were hiring an AI lawyer, if someone wants to work in your department, or what skills would we be looking for? So what type of, if someone wants to prepare to apply for a position in your law firm or in other law firms working with AI, what do you think are important skills or characteristics, or what the person, how the person should prepare to this?
So I think it sits within the technology departments of law firms. So like having experience in intellectual property, data protection, commercial agreements, software agreements, that's the basic level, you know. So you have to have, if I was hiring someone, the base level I would be looking for would be an excellent technology lawyer with experience in all of that, you know, data protection, IP, commercial agreements, IP agreements, software license agreements, and so on. But for me personally, I think the real differentiator is having an understanding of the technology, having a good technical understanding of the technology, being able to pick up a technical paper and read it and then understand at least half of it, I think is really important. Because in terms of, let's take an example of reproductions within AI. When you consider, you know, is encoding a piece of data an act of reproduction for the purposes of copyright, you actually need to know what's technically happening, what's actually going on. Like, what is vector embedding in a large language model? You know, for the purposes of actually what is the infringing act from a copyright perspective, you actually need to understand how these systems work. So I'd be looking for somebody who has that ability to understand that. So I think, and you know, how do you go about that? There's no easy way. I think I did a PhD on it. There is no shortcuts. You like to catch up, and it's something I do. I mean, when I get home and, you know, put the kids to bed, and then I am locked in research papers and reading and reading and reading. Same as you, Luiza. You know, it's just a constant. And I guess I found my passion. I'm really lucky. But I think you need to have that kind of reckless enthusiasm for the area, because it's so new and there's so much to learn about it. But I think you have to be willing to just throw yourself into it completely and be very, you know, ferociously curious would be how I'd put it. But certainly that technical element, I think, is super important.
I think you agree with me that it's a very competitive environment, right? Of course, everyone wants to have a piece of the AI cake. So it's probably hard if you, I don't know if you have an open position right now, but it's probably hundreds of CVs and people. Everybody wants to be in AI, and for the hype, for the coolness, and also for the career the growth and everything. If you're in AI now, you have the potential to grow and become a leader in a few years. So I think it's very competitive with everything in life. If it's something very competitive, remember, if you were, I don't know, apply for a university position or a master's or an MBA, you know, everything that is competitive, you have, as Barry mentioned, you have to be really focused and obsessed. Like the same way with entrepreneurs, and also if you want a difficult position or something that is everybody wants to be there, so you want to be really obsessed. I think Barry and I, we are very similar in the sense we're all, so we both of us have, so for people in the audience that think we are just single people without kids, so both of us have kids at home, so we are extremely busy, and still every day, even dealing with it every day, we are still every day focusing and reading and update. So there are new reports and lawsuits almost on a daily basis. So every day you have to, you cannot just say, okay, I want to work in AI, but I don't have time to read. I just go to work 9 to 5. I don't think it exists. If you want to be a leader, if you want to really get the best position, I think you need to go beyond. It's not like any job or, yeah, I want that position that everybody wants, but I don't have time to read. I don't have time to research. I don't have time to keep up to date. I think the bar is high, especially because it's competitive. Thank you.
Just yes, as a final note, and I think you see this a lot as well, Luiza, it's that I've been reminded of it increasingly lately. It's called the Dunning-Kruger effect. I'm sure many of the people here will be familiar with it, but it's this idea of people thinking they're experts when they're not, and having a little bit of knowledge is actually a very dangerous thing, because increasingly you're seeing people who think they're experts in AI, but actually really are limited in their AI knowledge and are spreading a lot of misinformation about AI as a result, because they feel like they're experts, because but because their information is actually limited, they don't realize how far away they actually are from having a good level of AI expertise. So I think one of the big problems, and I was speaking at an Irish state body today, and it was one of the issues I pointed out was being able to discern which expertise to use. And look, you know, I've been a fan of Luiza's for a long time. Long before she approached me for this talk, I was following her. I think she's excellent. Luiza would be absolutely one of the people I would have in my top of my lists for people to go to for AI information. But I think organizations need to be very discerning now about who they trust and where they get their expertise from, because you know, we will all remember GDPR. There was a lot of experts very suddenly when the GDPR was coming in. 2 years ago, LinkedIn was full of Web3 and metaverse experts. They've all disappeared. To know where they've all gone. But there's a lot of prompt engineering experts now and AI experts now. So these are things, and fully appreciate the irony of me saying this, calling myself an AI expert. But you know, hopefully the proof is in the pudding. But I think that is something to be wary of, and it's important to have leaders like Luiza in this space as well. So look, thanks very much for setting up these spaces, Luiza. It's important work.
My pleasure. Really, really, this conversation was really a pleasure. So thank you also for the audience for being so engaged. Barry, do you want to say some last words? Where can people find you? So what social networks are you active in, or you want to tell people anything, a last message before we conclude?
Yeah, absolutely. If you want to follow me on LinkedIn, just do a search for me. You'll find me. This might be the last few days of where I have more followers than Luiza, so I'm trying to enjoy them.
Oh, Barry. Wow.
She's caught up with me and overtaking me. So please get in touch with me on LinkedIn and do a search for William Fry Artificial Intelligence. Next week, we're going to be publishing. I'll reveal it here. We haven't revealed it anywhere else, but don't be telling anyone because it's still a little bit of a secret. But we're revealing our AI Act guide. So it's going to be this big bumper insights into the AI Act and all of the work we've been doing for a long, long time. So that'll be released today week, coinciding with the AI Act coming into force. So keep an eye on it and follow me on LinkedIn. I'd be delighted to have you. And Luiza, just wanted to say to you again, thanks so much. We talk about your posts all the time in William Fry. My colleagues say, oh, did you see what Luiza saying? It's like, yes, I've seen it. So thanks very much for all the work you're doing as well.
Thank you, Barry. So if anyone is interested in AI training, so at the AI Tech Privacy Academy, our summer bootcamp sold out. So I'm really busy every day. I have a bootcamp, so it's really exciting. We have 2 cohorts, one about the UAI Act and one about emerging challenges in AI tech and privacy starting in September. So save your spot because they will so sell out as well. Thank you, everyone, for joining. Thank you, Barry, and see you in the next live talk. Bye-bye, everybody.